All right, it is June 13, 2025. We are here today with an all-star panel of H&C experts. Raj Sharma, who was supposed to be on a few weeks ago. We had the episode titled, but then he couldn't make it, and I learned what happens when an episode airs with the title Raj Sharma in it, and he's not there. I get a lot of emails saying, "Where is Raj Sharma? We want Raj." Always a hit on our episodes. We may even bring up, I guess, your past cases because they weren't H&C applications, but they were IAD appeals for Miss Mohammed. Welcome back.
It's a pleasure always, and it's been a long time. Although we did meet at the conference
A few times. We did a scavenger hunt. We tried to follow you around.
I tried to mislead you, yes. But
yeah, you tried. No, you told us the truth that they weren't going to count something. We didn't believe you, so we went to that. Right? We went there, and we're like, "Aha!" Raj thought we were going to believe him that this wasn't going to count, and then they told us this doesn't count. So you were right.
Deception and misdirection are powerful allies in litigations.
So if you're wondering,
you sound like Emperor Palpatine in the way that you're talking.
We just all came back from the CBA immigration conference, and they had I can't believe you guys went on it. I needed any time to recover my energy, so I just chilled rather than going on a scavenger hunt.
Something.
Yeah.
Also joining us today is Hannah Lindy, who works at our firm and is our firm's resident guru on H&C Applications, which is the topic for today. H&C stands for Humanitarian and Compassionate Applications, a growing area.
Yeah, first time. Yeah,
it is. Long-time listener, first-time caller.
There we go.
Cool.
So why don't we start with you, Hannah? What is an H&C application, and why would someone want to file it?
So an H&C application is an in-Canada application for permanent residence. The authority for making this application is under Section 25 of IRPA. And it's, when we look at our PR application streams in Canada, we've got, family sponsorship, economic, and then humanitarian/refugee. And so the in-Canada humanitarian application can be made by almost anyone in Canada. There are some restrictions. And the people who make these kinds of applications tend to be people who aren't eligible to apply from outside Canada, or who can't apply under some other category or stream for permanent residence. So it can be people who are out of status in Canada and have been for many years, people who have some kind of temporary status in Canada, but again, they don't fit under any of the other categories. Sometimes failed refugee claimants. It's really a very, very broad category. And I imagine they get a lot of applications from people in very different circumstances.
And what is the general test that IRCC is looking for?
So the general test, to put it very, very simply, I think, is whether looking at the applicant's circumstances as a whole, whether that warrants granting them permanent residence on humanitarian and compassionate grounds. And officers also have to consider as part of that the best interest of any children who are affected, and the best interest of the child factor that's baked into the language of Section 25 of the Act.
Yeah. What, any of you, I guess, maybe Raj, probably all of us receive emails, correspondence, meet with people who don't have any options for permanent residence, especially now with lotteries in the parental grandparent program, hugely high points thresholds for express entry. What sort of factors and things are you looking at to decide whether H&C makes sense for this person?
A humanitarian and compassionate application is necessarily subjective. Subjective in the sense that we've got the factors that have been set out in various forms or another. And there's a great, if you read Kanthasamy, the Supreme Court decision, you'll get a nice sense of the historical operation of Section 25. Suffice it to say, there's always been a provision under the IRPA or the predecessor legislation to soften or mitigate against these sometimes harsh or rigid consequences of the act as a whole. So the traditional factors that we see in the jurisprudence, in the manuals that the officers are supposed to have regard to, we're supposed to look at the nature of the, let's say, the nature of the non-compliance, or the nature of the request, I suppose, or the circumstances of the individual bringing the application, or the need for the application, but their establishment in Canada, which is more than just time in Canada, but sort of their ties to this country, and the impact on them if they had to leave. There's the family in Canada and the dislocation to that family in the event of if relief is not granted. There's, of course, hardship and return scenario and best interest of the child that Hannah pointed out, but it's sort of non-exhaustive in the sense that the key is to bring forth almost a Shakespearean test. And whether that's Justice Harrington, I think, in Espinoza, or in another case prior to that, very, very subjective. Can you hear a good man groan and not relent and not compassion him? So now,
this is not the first Borderlines podcast where you've quoted Shakespeare, just saying.
In this case, I'm quoting from Justice Harrington, who was quoting the bar.
Okay.
So this is sort of like hearsay Shakespeare.
I love that you put it like that, though. I do think it is Shakespearean.
Totally, 100%.
It is Shakespeare, and so you have this, like, when Stephen asked a very good question, and what I would say is that I'm a sympathetic individual, perhaps more so than Stephen.
Perhaps. We were talking about this before we went on.
Yeah.
I don't know.
I think even in Kanthasamy,
I need to feel something. So again, if you go back to Kanthasamy, you talk about these historical tests, the Cherwat test, right? And it's that same thing. The circumstances are such that would a reasonable person in a civilized society feel motivated to assist? And so again, we're very Shakespearean, very eloquent language. We're trying to express something, which is, will an officer have the objective and basis that gives rise to a subjective animus to exercise the broad discretion allowed under the Act? So back to Stephen's question, what do I look for? I look for something that stirs the heart, or can potentially stir the heart. And again, it's another test which is not applicable, let's say, if it's but you know it when you see it, I suppose, or hear it.
Yeah, that's just right. Like, I think it's if the officer doesn't cry at the end of reading the submissions, it's not a viable H&C as I see it. And so I used to find it was much easier to do like a gut check on what is going to be a viable H&C. I used to have a pretty clear sense of whether something was going to be able to be successful. But I think that the category has been very much transformed. Well, first it was transformed, as Raj says, by the Kanthasamy decision, because it had become somewhat fettered by this unusual, undeserved, and disproportionate hardship. And that decision basically said, no, it really is more to be decided by this Shakespearean kind of standard, what would shock the conscience of the Canadian, the average Canadian, and what would a reasonable Canadian in a civilized society. It went more to that. What is a situation that should drive compassion overall without these specific constraining factors? Because we did start to see more like, well, this isn't disproportionate as compared to everyone else. And so it did get kind of fettered. But I think that because the levels plan has so constrained the number of H&C applications that would be approved year over year, it really has thrown off what my sort of evaluation has been, because with such a limited number and with so many people in such difficult circumstances right now because of all the various things going on around the world, I have a much harder time saying, yes, this one rises to the level. Yes, I think that I feel very confident that this is going to be a very strong H&C application. I'm curious whether both of you also feel that giving clear advice has become much more difficult in the last year since the levels plan came out.
I think it absolutely has. I mean, I still tend not to tell clients, so I'm extremely confident that this application is going to be approved, because the nature of H&C applications is so discretionary. I mean, I agree with you, Deanna. Like, I think that, once you've done this for a while and done enough of these applications to see what gets approved and what doesn't, you sort of do a gut check, and you have a fairly good sense of what is going to be a strong H&C application. But yeah, I do think that has gone out the window somewhat. And so I find myself more recently telling people, like, look, I can tell you what is strong about your case, what the weaknesses are. But at the end of the day, it's coming down to an officer. And when they look at your file, as Raj said, is it going to stir their heart? Are they going to actually grant you permanent residency? And I just don't know. And with the increase of applications with the levels plan, I think it's going to be even more difficult to predict going forward what applications are and are not going to be approved.
So that levels plan, I'm not going to pull up the actual plan on YouTube, but the target this year for total humanitarian and compassionate and other, which includes the Ukraine, Sudan, and Hong Kong programs, the target this year is 10,000 people admitted, not applications approved. So that includes family and kids, dropping to 6,900 next year, and then 4,300 in 2027. So the number of people that the government plans on admitting is going to go down by half. At the same time, there's no reason to think that demand for the program isn't going to increase. Especially, we haven't really discussed it on the podcast yet, but with like something like Bill C2, which is going to restrict asylum claims. And so where do you see this category moving forward? Like Raj was saying before, that demand for this is going to soar. How do you measure that against what should be a program that admits half as many people 2 years from now as it does today?
Well, I mean, one thing that really struck me during the conference was that it's very clear that any kind of relief efforts that the government runs throughout the year, like if there's a natural disaster that happens, we've always in the past created special quotas for like, this group is affected by this natural disaster and they need to, we create some accommodation. Those are all coming out of the same allocation. And so, they tend to be pretty small allocations, but still that does eat into the same group. But I think that right now, like, especially when you look to the CUAET program, like there are a large number of people, there doesn't seem to be any stated intention to create a separate, permanent residence pathway. So there are just a lot of people here that still are not able to return to Ukraine. Some people that I've spoken to, the place where they came from is no longer Ukraine. So like a lot of very meritorious applications right from the outset. So it means that somebody who's just not eligible for permanent residency because the score has gone too high, it's very hard to imagine that those are going to be kind of competitive for a spot in the H&C allocation as compared to people who like are actually coming from an unstable region, or people who have like severe health issues that will not be addressed in their country of origin. So it's really kind of shifted the balance. I agree with Hannah that I'm not saying to anyone right now that I'm super confident in it in any case. I'm saying that, it's very hard to imagine, especially because I think a lot of cases don't get decided in the year they're applying. They get decided in the next year or the year after. That I'm much more cautionary about who I say, yes, this is a viable application.
Do you want to talk also, I can't remember if it was Raj or Hannah who mentioned first stage approval, what that means in the context of an H&C application, because these levels plan numbers would all pertain to permanent residents being granted, but the processing of an H&C application goes in 2 steps. What's the benefit of like the first stage approval?
The first stage is whether there's sufficient humanitarian and compassionate grounds to consider the request for either an exemption from the requirements of the Act and or permanent residency. Both of those, there's a significant overlap there. So in essence, you're asking for permanent residency, but that's that first stage. The second stage is then going to assess inadmissibility largely. So that's the 2-stage process for the agency. Now, going back, I just want to comment on this in terms of the levels plan. I think that it is true that sympathy now appears to be in short supply. And so as demand goes up, and there's finite resources, our sympathy for our fellow human tends to go down because human beings are self-centered by nature. I mean, it's Nizar Kabani, I believe, who said that we wear the cape of civilization, but our souls live in the Stone Age. But this is not just Canada. This is the UK. This is the US. Look around the world, and migrants and asylum seekers are facing greater scrutiny and larger hurdles to secure status. In terms of the levels plan, I think, again, man plans and God laughs. We have an administration to the south of us, and it is difficult to see how we would be able to manage or stop an influx of significant numbers. I agree with Deanna that how do we present advice now? It's difficult to say. So if you look at reported decisions or the reported decisions that I have, everything that makes it to the federal court, and hopefully we succeed, those are cases that we thought were meritorious. So obviously we're not, we can't. There's the vagaries of this subjective assessment. So the closest I got to the Supreme Court was Abu Bakr. My case went to the federal court. Justice Rennie cited by approval by the majority in Kanthasamy. Abu Bakr was from Niger, one of the poorest countries in the world, where food insecurity impacts the majority of the population. And the officer didn't consider the hardship that arose because the officer said, well, this is not particular or unique to the individual. It affects everyone, and therefore it's not deserving of sympathy or consideration, which is, of course, nonsense. Shrestha was one of a large cohort of Nepali agencies that this office filed after the devastating earthquakes of 2015. We succeeded on all of them. Shrestha, again, same situation. The officer seemed to take issue with the fact that this natural disaster, which impacted hundreds of thousands of homes and infrastructure in an already poor and failing economy, again, did not disproportionately impact our client. Again, that was a success there. A failure to navigate the immigration system. Bahadur Singh, I was before Justice Ahmed there, 13 years as a temporary foreign worker, was taken advantage of by his a sort of immigration consultant and thereafter a ghost consultant. And again, the officer seemed to not approach it with that empathetic lens that we've seen the court is asking the officers to employ, whether it's Justice Campbell and Dowers, for example, and of course other decisions by other noted jurists. So I agree with Diana and Hannah in the sense that it's very difficult to give advice, because obviously the ones that we go forward on and prepare ourselves are the ones that are ending up in federal court. We can take some solace in the fact that we're winning as well. So we have a good sense of that. In terms of the settlement plan, or let's see what happens. In the words of Mr. Trump, let's see what happens, whether we can adhere to that as well. But I guess the other thing I'd like to say as a corollary to Deanna is that all of these individuals that are going to fail to navigate this immigration system, international students that have been here for a brief period of time, that on its own, in my mind, is not enough to meet the threshold. And I fear, or I'm concerned, that a lot of these applicants are being sold false hope.
Mm-hmm. Yeah, I couldn't agree more with that. Frankly, I'm declining to take those retainers because I feel like that hope can be really dreadful. And also I'm just seeing the volume of people who are dealing with really just hugely distressing cases where the facts just are of a different ilk. And I think that, I don't like selling people a bill of goods. And I feel like those don't strike me as being ones that are likely to be successful when balanced against, especially given the numbers, when weighed against the other types of applications, which are really, just, they've got a lot more. I mean, the thing is, one thing that I would say, and this kind of feeds off of what Raj is saying, is that we've never seen the same volume of positive decisions in federal court of judicially reviewed H&C applications. This was something that I, when I was litigating them in the past, there was much more deference they're like, well, they're wildly discretionary, and there was very great reluctance to intervene on a decision that had been made by by an immigration officer. And now I find they really need to articulate a good reason when it's a highly sympathetic case. And so I think that has, to some degree, elevated the decision making. But I think that where there isn't that really substantive reasoning provided in the application itself, I don't think that those are going to be sustainable.
Well, one thing, and this touches on what both you and Raj said, is that while the sentiment towards H&C may be changing at the IRCC level and the numbers are high and refusal rates are high, the facts on the ground in a lot of cases aren't getting any better, right? And so one of the things that I found, and I think it's reflected in the jurisprudence and certainly my own judicial review cases, is that because officers are looking at very sympathetic facts, but they're inclined to refuse, their decisions wind up misconstruing the facts such that judicial review becomes a bit more straightforward. It's like last year or 2 years ago, Chief Justice Crampton, in one of my cases, Sharma, that case involved someone where there was a family in India, mother and father, a child in Canada, and then a son who had been murdered in India. And the decision in the officer has, about maybe half a sentence dedicated to the son who had been murdered, which was the whole thrust of the application. And the rest of the officer's decision talks about, well, the separation of parents from their children can be expected in immigration. And it was just, our argument was like, not everyone's child gets murdered here. This is not. And another one that we just settled yesterday was someone, I'm sure you've seen similar cases where someone in country of citizenship is basically in a civil war, and the officer will write, while the socioeconomic differences between Canada and X country might be different, this is not that, people regularly come from countries that have a different socioeconomic difference, which doesn't reflect at all, as we put in the submissions, it's basically a war zone. That's not a simple thing of socioeconomic difference.
For sure.
That's at least what I'm noticing, is that
me too.
It's hard to write, when it becomes hard to write refusals based on the actual facts, the facts get a bit misconstrued.
Yeah, and when you get those boilerplate, I have considered the best interest of the child, but I have determined that these are not sufficient to overcome the, that we never promised in this case that there would be permanent residency at the end of this. Those types of boilerplate kind of refusals are not sufficient when they don't engage with the severity of the facts. I totally agree. I had one as well where a little boy, it was an H&C to overcome a 11790 exclusion, where a child had not been disclosed, but the mom was a very young woman and was not disclosing to her mother, who was a caregiver, that she had become pregnant because of the stigma and, Catholic country, all this sort of thing. And the child who had been excluded had written the most tragic letter that I've ever read in my life, saying he'd been abused and all this kind of stuff, and please let me be with my mom. And that had been overlooked completely, and just it was very shaming of the mother for not having disclosed the existence of this child, those sorts of things, and this child really being denied the necessities of life, things like that, when you're I've considered this, but I don't consider this to be sufficient, and very blaming of the mother, things like this. I think that when you have such compelling facts. But I mean, something that I saw today, just Nicholas Kiang just wrote an article about, the number of refugees accepted, and, Canada is such a compassionate country. I think that what we are seeing on the ground is that even though the circumstances in which people are coming are highly compelling, Canada is changing its approach, and it's changing its approach to say there are just too many. And so it's this conflict that we've been talking about a fair bit. Like, yes, there are too many, but there are also still these precedents set up in law for like when somebody actually just meets the test. And no matter how you write the decision, like they just meet the test. And so we're struggling with this a lot in the humanitarian and compassionate, in the refugee setting, that like when the capacity or the desire, the intention to absorb is different than the actual whether or not you actually meet the requirements. And so I think that this is the struggle in this area.
Yeah. On that note of compelling grounds, one of the questions that we got, and maybe you can take this, Hannah, is you had mentioned best interest of the child, Deanna, and we've talked about compelling cases. We got questions similar along this. One was, does there always need to be a child involved in an H&C application, or if there's no children, is it automatically refused? Does the grounds of H&C always need to be dramatic and heartbreaking? What if it is just someone's been here 3 years, they're established to a degree, and there's no clear permanent residence pathway?
I mean, the short answer to the first question is no. It doesn't always have to be a child. I mean, the best interests of a child who's affected by the application do have to be considered, but I'm sure Deanna and Raj, you can speak to this as well. Like, I've had a number of clients where there's no children involved, there's no best interest of the children to be considered that have been approved on the individual facts. I think the second question about, what if there's just no clear pathway to PR despite having, been in Canada for 3 years. I mean, I think this goes sort of what you were saying, Deanna, where we're just going to, I think we're already seeing this influx of people, former international students, people who are work permits, who just don't have the points to get in under express entry. I agree with you. I don't think that is probably going to cut it, especially when officers have other cases where the facts are just truly more compelling. And I still think that people who have been here for a long time and they don't have a clear pathway to permanent residence, I mean, to me personally, like, I find that very compelling, but again, it's is an officer going to find it compelling? And I think that comparatively, they probably won't in most cases.
What do you think about this, Raj?
I'm on board with Hannah. I guess what I love most about the H&C application
is you get to quote Shakespeare a lot.
Raj does that anywhere.
That too.
And Eminem, it rotates. Shakespeare and Eminem.
But it allows you to step into the shoes of the applicants and understand their lives. And I find that that's one of the parts of this job that I love. As you know, litigation is difficult, but it allows you to use your skills of advocacy, whatever that is, whether it's written or oral, whether it's quoting Shakespeare, whether it's country conditions, whether it's connecting the dots. It allows you to engage a core skill of being a true lawyer, which is advocacy. And it's incredibly rewarding once you get that first stage approval. It really keeps you going. It keeps you motivated through the stay applications, through the fighting in the trenches. So the H&C is so fulfilling, I think, for the lawyer as well as the applicants. I think that in line with what Hannah and Deanna are saying, you need some kind of hardship. Now, again, hardship is the subjective word, or whether we talk about Punjabi, Hindi, Urdu, mushkilat, or takleef. You need hardship that is beyond just the normal operation of the immigration system, which is you're here as a temporary resident, permanent residence wasn't necessarily in the cards. You would need to show some hardship. And then you need evidence. And so, yes, it's entirely possible to win an H&C without a kid, although you need a kid to beat out the 12-month bar against H&Cs for refugee claimants, and we should probably get to that as well. The limitations of H&Cs doesn't apply to 34, 35, 37, for example, but I'm sure we'll get to that as well. But hardship and BIOC, not necessarily BIOC, but it is a significant factor. And then how do you establish it? It's evidence. You have to show evidence. And what is evidence? Which is statutory declarations, bank statements, income tax returns, objective country conditions, psychological reports, medical reports, school reports, letters from teachers, letters from your friends and family. And you combine that, the facts, a true understanding of the facts, you apply it with the jurisprudence and the manuals and the legislation, of course, and you put together a complete package for the officers' consideration, making it easy to say yes, making it hard to say no.
For sure.
So that's, and what we have to do is we have to be continually creative, and we have to be continually curious. And, I want to thank Stephen for his research, his tweets. I mean, I've used his tweets on H&C applications on approval rates for this office versus that office, for example. And so, again, I love the collegiality of the bar. We just came back from that National Immigration Conference in Victoria. We're sharing precedents. Ron Lee Carey and Erica Olmstead did a great presentation on H&Cs in Victoria. They're sharing their precedents. They're sharing their case law bank. The H&C is not an impossible mark, but I think it's important to use experience counsel that can give you a realistic assessment. And I think people should also know that filing an application does not give you any status in Canada, will not give you any work permit or healthcare coverage until
approval on principle.
Willing of approval.
Which might take 2 years to get.
People should also know that you don't have to do a standalone H&C. You can do a standalone H&C to Vancouver, but you can also use H&C with other applications that are in the mix, and you can even use H&C relief for applicants outside Canada. So very, very flexible, very powerful remedy. I know we've been, maybe a little bit, and as good advocates, we are advising some of the challenges as well. But that H&C is a powerful remedy that can overcome criminality, convictions in Canada, can overcome misrepresentation, grounds of inadmissibility, can overcome any number of things other than
medical,
34, 35.
Serious, what is it? Other than security, human rights violations,
family members, some forgotten aunt from back home in the village, we can get her here. It remains a powerful remedy under the immigration system, and it is only going to get more and more important because of the rigidity of the system itself.
Yeah. So speaking of Victoria, a lawyer who I met for the first time in Victoria, he was presenting on removals with Michael Green, who's been on the podcast before. Justin Toe asked us this question: I'd love to hear about skeleton H&Cs and how long IRCC is currently willing to wait for the perfection update before proceeding to a decision. Is this a practice that you do, where you submit a bare bones H&C application just to get into the queue and then update it later? I know, Hannah, when we spoke at a consultant conference last month, you talked about the importance of updating applications, but we didn't really speak about skeleton, bare bone H&Cs. Is this something any of you do?
Sometimes, but usually it's only when there's a family class application that I could file with H&C submissions to overcome an admissibility issue. And the reason I would sometimes do that is in order to forestall removal, where it's a genuine, and again, it's not perfect. And I do file, it's not really a skeletal, it's a substantive one. But and then I almost immediately file the remaining material. I have a
feeling Deanna's skeleton H&Cs is probably better than most.
They're pretty thorough. It's something if I need to do a
novel instead of an encyclopedia.
Yeah, that. Yeah.
Hannah's advice is spot on. Always update. These things are taking. We diarize. We diarize every 4 to 6 months. You update with tax returns. And at a certain point, you got to ship the product.
Yeah.
And so at a certain point, it depends on the client. Sometimes the client is difficult. We're not getting the documents. At a certain point, we will pull the pin, we will submit the application, and then we'll go back to the client to get more supporting documents, and you update on a regular basis. It's easy to update, and it should be done. Failure to do so, I think, I don't understand why an H&C application would not be updated.
Yeah, I have to say though, going back to the last question to some extent, but also building off what you just said now, Raj, is that the question about does there need to be a child? No, but does it always need to be compelling and dramatic? Yes, but there are definitely situations in which I have succeeded, but it can't just be like, I've been here for all this time and I want to stay. But there are numerous circumstances in which, like as Raj said, what's going to happen in the country of origin, whether or not you're employing many Canadians, like what is the degree of your contributions to Canada, how much, what would Canada have to lose by you not being able to remain? Was the loss of status, for example, because of an honest mistake or because you were actually the victim of fraud? Like it's again, they're all super fact specific. But also what Raj said about this is a really good opportunity for good advocacy. This is one area where I feel like it's not just whether or not you've been non-negligent, but I think the power of doing a well-written H&C will really make the difference between an approval and a refusal, because it matters how you write it. Like this is where, I will quote Thomas Hardy, where like we're in a situation where it's like we are too many. And so you really need to have an application that stands out, where it does matter the language that you use. It does matter that, you answer all of the concerns that the officer might have and address those head on. So that takes some experience as to like, what is the officer going to think? What are the typical objections that officers have? And you address them up front. So good advocacy is really important here. And I would say that that's not so much the case in other areas, but this one is one where you can really get a value add.
We were talking, I don't remember where we were talking. Maybe it wasn't even in here, about when you do cover letters, when you don't, when you do submissions, when you don't. Would you say in an H&C application, it's imperative to always have a cover letter with detailed submissions?
Yeah, you have to do that. I think if you don't do that, you're negligent, doing a huge disservice to your client. And beyond the cover letter with legal submissions, I think best practice is to do a very, very detailed stat deck from the applicant, or more than one if there's more than one applicant, that really sets out in huge narrative detail their story, where they're coming from, what they've been doing in Canada, addresses gaps in the documentary evidence, and really ties it all together. And like Deanna said, addresses upfront any questions or concerns that you sort of anticipate the officer could have when they're reading through the application.
And it has to not sound like a lawyer's affidavit. It has to speak from your client's voice. So you have to spend a lot of time with your client, capturing their own thoughts and feelings, literally, just the lawyer's role is to translate, like to really communicate. Because often when you're getting a stat deck and an H&C application, it comes to you very garbled because people are very distressed, but you have to like put it in a nice order, make sure that it's very distinctly from the applicant's own thoughts and feelings.
Is there anything you would change about the process? This person says that it shouldn't be visa officers who are deciding it because of the pressure of the numbered count, and that it should be a neutral humanitarian agency. Any thoughts on that or the process at all? I see Raj shaking his head.
Well, why do we have administrative law? Why do we have statutory tribunals? We do that because given the volume of a particular application, these things are unsuited for courts and formal structures. They would have to be done by officers. That's the only way to deal with tens of thousands of applicants. What might be interesting, however, is that in the UK, on an asylum claim, they assess asylum, and in the event that asylum is not in the cards, they also assess humanitarian grounds, whether to grant stay on that basis. So yeah, that might be interesting. You got 280,000 refugee claimants. It might be very interesting if you expanded the discretion under the Refugee Protection Division to see whether you can say like, okay, well, they're convention refugees, or there may be a basis to grant some kind of status. And maybe we're going down that way as well. If we can't land permanent residents, if we can't do 5,000 to 10,000 a year, or that's the most, and we got 60,000 in the queue, maybe again, we go down the UK pathway and we grant indefinite leave to remain. We grant some sort of status above that of a work permit or open work permit, something below PR. That might be a way to manage the present backlogs and strain on the system.
Yeah, that's what the CDA has recommended. I was on the working group that drafted the 100 recommendations, and we have recommended that, or the CDA has recommended that all of the H&C refugee claims be brought under one of those tribunals, like either within the IRB, so that we can have that kind of continuity rather than have it all fractured among visa offices abroad, in Canada, that there should be a single process even for, if we ever get back overseas refugee claims for anybody other than from Sudan, that there's like a uniformity, consistency, transparency, reviewability, all that sort of thing.
I'd be stunned if it happened, but good on
me too,
CDA
but
for
I
asking.
honestly, I think that it would be a real elevation.
So we have a live comment from YouTube, which is Mr. Raj, bravo and well said. Your approach might seem complex, but I really do see the point. One of a tangential question, since there wasn't really a question, but that gets brought up is that these are complex applications. And the sense that I'm getting, if it hasn't been clear already, is that it's not really possible to commodify them or do shortcuts, and that each of these applications, like how many hours would you say you go into meeting with clients, preparing? Raj's eyebrows are going up. Hannah's grimacing. Deanna looks like she's choking herself. But
on writing submissions alone, and I write very quickly. Writing submissions alone, I think the written part is 3 hours. It's about 2 to 3 hours. It's just writing. It's just the submissions, and that doesn't include application preparation, the review of the client documents, the meetings with the clients, all this. There's a lot of back and forth. It's time intensive.
Yeah. With the meetings included, I think it's close to a week of like solid intensive work. Yeah, and the research. It depends if I've done other claims from that particular region before, but like it's intense.
Yeah, the country condition review, the past refugee decisions, the RADs, the federal court, the other case law update, review of case law, like it's hours. It's hours.
Yeah.
I want to say I want to point out one thing. I think Hannah mentioned this as well, or Deanna did, but bear in mind when we talk about compelling, or we talk about something dramatic, we don't need a Bollywood movie. We don't need Shah Rukh Khan weeping, and we don't actually need that. It depends on the nature of the request. The H&C, the exemption, or what we're asking for the officer is commensurate with the nature of the non-compliance or inadmissibility.
For sure.
Example, I have a long-term temporary foreign worker from Fiji in Canada for 10 years. All the kids are here. They've spent all their schooling in Canada. They come from a one-room house in Fiji, which was made out of tin, and Cyclone Winston has devastated the low-lying areas of Fiji, which is where they're from. They're poor. He attempted to navigate the PNP system, and he's always half a point short on the language requirements. And he's done the IELTS 5-6 times. Now that ask is pretty direct. He would have made it but for. So those magical words, like my client would have been a permanent resident but for. My client would have been a permanent resident but for the fact that she became 7 days after her father became eligible to sponsor, or the father was a permanent resident himself. So the but for is really important. And so what's that gap? The bigger the gap, the more the H&Cs, the more compelling it needs to be, the more melodramatic or dramatic or compelling it needs to be. But if the gap is this much, then you need that much. And so
yeah, for sure.
That's also important as well. Like, so again, a good lawyer is never going to use percentages. A good lawyer is always going to be a little bit careful in terms of asking for discretion or remedy or giving that advice. But at the same time, it depends on the circumstances under which the application is being sought. What is the nature of the inadmissibility or non-compliance? That informs the level of the agencies. So yeah, you have a crime.
That's so smart. Yeah,
you're going to need that much
for sure. And like, I mean, conversely, if your client is trying to overcome a medical exemption and they need dialysis every day for the rest of their life, it's a big ask because of the cost. And so you need to understand that, you know, it, as Raj says, exactly, it needs to be commensurate with the exemption you're requesting. They do look at the dollars and cents of it. And so, you know, you're going to need to come up with extremely compelling agencies.
Do you always recommend that clients get things like psych reports, counselor statements?
Really depends on the facts. Yeah, I mean, to me, somebody who's seen you once and is like, this person is going to suffer hardship is worth much less than somebody that you've been seeing routinely for 3 years.
Mm-hmm.
It really depends on how much turns on the psychological component. I don't just do it for the sake of it. But if this is somebody who who really is going to suffer because of something fundamental to their mental health, then you know, it will depend whether or not that's something they have been receiving treatment for. And, you know, but I don't do it just as a boilerplate. This is something you need in order to make for a successful application.
We can take some guidance from our brethren and our brothers and sisters in the family law bar. If there's children, if there's an issue of separation with one of the parents, you can use, you know, they use those experts all the time to inform the court as to the best interests of the child or the impact on the child as to the separation of a caregiver or a parent. So there's a great deal of scope for the use of such expert opinions, again, discussed in Kanthasamy. Be careful, though, of the adverse case law in the federal court, the hired gun expert, the advocative expert. Watch out for that. Use those individuals that are used to the court process, that's going to maintain their objectivity. You got to stay away from the bias, because you are going to sink a potentially strong case if you give the officer some concerns as to the nature of that expert opinion.
Sure. One that I've done that was exceptionally useful is in the case of trauma, like where one of the reasons why somebody does not want to return to their country of origin or citizenship is they've suffered. And actually one that was the most helpful expert opinion was they actually did, this was to like explain the neuroscience of the trauma. And they actually did a brain scan and showed through the brain scan the evidence of how the trauma had impacted their development. And it was really a fascinating report. And I do think that it led to a positive decision where they had suffered severe childhood trauma. And every time that they had to confront the idea of being returned to their country of citizenship, they suffered severe post-traumatic stress, and it had actually resulted in like a learning deficiency. And it was really wild how it showed up on the brain scan, the degree of atrophy of certain parts of their brain. But it was like, you know, based on real science. And I think that did have a meaningful impact. They're expensive is the problem. So
and that's one of the unique things, is that because this is the most discretionary areas, your express entry CEC candidate is basically a reference letter, or maybe one or maybe two or three. H&C, like we kind of joked, is either a novel or an encyclopedia.
Yeah.
So the most vulnerable and heart-compelling stories do take a lot more time to prepare.
And I'm doing one right now with a child in their country of citizenship was not able to access various medical or educational tools. And we had letters from experts in their country of origin saying, this is just not a thing here. And getting those doctors in the country of origin to write those kinds of letters is very hard, because like, which doctor wants to say we don't have the capability of dealing with a patient of this nature?
Well, and it's one of the ways that they will refuse. Like a common way to refuse this is, let's say the kid in Canada is receiving some sort of medical care, and the applicant, the mother, the father, says, well, this care is not available in, I don't know, Angola.
Yeah.
The officer will say there's no independent evidence to confirm what the level of medical care is.
Right.
Just looking at the time, final thoughts from any of you on this category? Things that you would, like, if you had 1 to 2 sentences of what you would want people to know, or information that they can provide if they, contact you about one of these.
Whoa.
That's a lot to distill into 2 sentences.
2 sentences.
I would refer individuals to this excellent text that does cover off the H&C as a remedy.
That's like the genie wish of the third wish being more wishes, where you turn the 2 sentences into a book.
I think if I agree with Deanna on that point, you would have to have expert witnesses when you have, for example, a medical need. The child is autistic, the child has a particular condition, and you need to sort of assess that and the treatment that they're getting right now versus treatment going back. So on that point, if it's about final advice, address the scenarios at play. What happens to this family unit? What happens to the children? What happens if they get to remain here? It's sunshine. It's blue skies. It's this vista of unlimited potential and happiness and poetry and unicorns.
Oh, I was going to say unicorns.
Huh.
And if we go
Rainbows.
back, it's going to be the land of Mordor. It's going to be Sauron and his armies sweeping across Gondor and Rohan. It doesn't have to be that clear, but you must address the scenarios, which is and back it up with evidence. If you grant an exemption, this is what happens to my family. And it's my family now, right? My family, my client. And if you don't grant, this is what is going to happen. And it's going to be A, B, C, D, right? And it has to be realistic and based on the country conditions and the available evidence, plausible, credible. Maintain your reputation when you do this. Stephen's got, he's being praised by officers as to his reputation. That reputation matters.
Yeah.
So
Really does.
don't overplay your hand, but certainly don't shirk from your responsibilities either. So that's what I would say in closing.
Yeah.
Awesome. Deanna or Hannah?
I would say that don't overplay your hand, not just because of your reputation with officers, but you don't play with your clients' hope. I think we owe an ethical duty to our clients to not take advantage, particularly in this kind of a situation, and really be ethical. The other comment I'm going to make is that the idea of disconnecting, making it so that refugee claimants can't simultaneously apply for humanitarian and compassionate status, that needs to go. There's absolutely no logical reason why they should not be allowed to do both. The distinction between a refugee claim and an H&C application is very challenging to make, and making people choose one or the other doesn't make any sense. The reason it was introduced was because it forestalls removal, which it 100% does not. But I think that needs to go.
Well, after Bill C2 comes in, they won't have to worry about that choice. And what you raised there is an interesting, because on terms of playing with hope, one of the frustrating things about being a lawyer sometimes is you can have 4 lawyers say, look, I don't think the odds of this are very high. And the client will go to the 5th person who says, guaranteed success, give me $10,000, $20,000. And the client often will want to go to who they want, to the person who says what they want to hear.
Yeah.
Which is a tricky thing. Hannah, final thoughts?
I think just from my perspective, it's well worth putting in the effort and the time up front to put in an application that's as complete and as strong as possible from the get-go. Going back to Justin's question about skeleton applications, I've put them in standalone H&C applications a few times in the past, but only where, there was maybe we're going to have to do a stay eventually, or there was some real urgent need to just get it in so we could say an application had been made. And of course, obviously you update it and put in like a fulsome application after that. But these are information document heavy applications. And I think sometimes clients think that you just slap them together, like, as long as you put the application forms in and the documents that are in the checklist, like that's the application. But really, as both Raj and Deanna said, these applications take hours to put together in the research, the writing, the interviewing the clients, getting to know them, figuring out how to best advocate for their case. And I think that even if it takes longer to put together, you absolutely have to put in the time and the effort up front. Because again, the burden is on the applicant to put in front of the officer any factors that they want to be considered. An officer is not going to come back and ask you, oh, hey, can you clarify this? Can you give me more information on that? Like it's all on your shoulders.
For sure.
It's such a dense topic. We've been talking. Raj just messaged me saying we could go for another hour on this. And it is one of those topics where like you talk for an hour, we've touched like the top of the iceberg in terms of everything out there on this. But people do have questions. They can contact any of us, but we are out of time for today. Thanks for coming on. This will be an episode that says with Raj Sharma, that has Raj Sharma. And awesome. Take care, guys.
Thank you so much.
Thanks a lot. Take care.